Okay, so we're talking about offensive battery, and one of the questions that comes up is what's offensive and how do we make that determination? And so that brings us to the Leichman case. And let's see, Jordan White, can you tell us about the case? How did this case get to the appellate court? What are the circumstances?
So the defendant filed a motion to dismiss, saying that there was no basis for a claim, basically no cause of action, and the motion to dismiss got granted, and now the plaintiff is appealing to the appellate court.
Right, so he wants to have his day in court, right? He wants to say, well, the facts here give me the right to get to a jury. Tell us a little bit about what happened here.
So this guy, Aaron Leichtman, was a self-proclaimed like celebrity in
Yeah,
anti-smoking.
right. Not just any celebrity,
Yeah,
anti-smoking, right?
yeah. So he was going on talk shows, and I'm sure he's trying to get his face and voice everywhere about anti-smoking. And this was only the 1990s, so it's a little bit different than now,
Right.
and a little bit different than it would have been before. And he was basically just trying to get the word out. And while he was on the talk show, the host of the talk show, like purposely, I'm not sure if it was a cigar or a cigarette or something, but purposely blew the smoke in his face.
Was it the host of the show? Are we sure about that?
Yeah. Oh no, it was a host of a different show under the same company, WLW. So
Right. So it was another employee who was in the building at the time who maybe didn't like what this guy had to say about anti-smoking. Perhaps the host of the show he was on would have been less of a jerk, right? So this guy blows smoke into his face, right? And so he then sues for battery, right? And would this be a harmful battery or an offensive battery?
I was thinking offensive, just because I mean, you could get scientific and say that maybe secondary smoke could be harmful, but it's tougher to prove in such a short amount of time.
Yeah, I mean, it's like 4 seconds of secondary smoke probably isn't going to do anything. Be very hard to prove, but it's certainly offensive to have smoke blown in your face. Why do you think we have to speculate here, why do you think the lower court might have dismissed this case?
I'm thinking just because of how pervasive smoking indoors was at the time, that well, it's kind of like you walk into a building, you might get smoke in your face.
Right, right. And so the lower court might have been thinking, well, does it really matter whether this guy did it intentionally or whether there was just ambient smoke? There's going to be smoke around. When I first started working here, uh, you know, into the 1990s, people were smoking inside all the time. So that's not too surprising. What would be the case, does the court suggest, if he had tried to sue everybody in the building who was smoking at the time he was there? Do you think he would have succeeded, according to this court?
Just looking 1 second here. It was confusing because we've been talking mostly about physical contact, and now
Yeah.
it's kind of a different.
Well, okay, so let's talk about that for a second. Because for battery, you do need a contact, right? So is this a contact, according to the appellate court here?
Yes.
It is. Okay, why? What about it's smoke? How is that a contact?
Yeah, they bring up how tobacco smoke is, I think they call it a particulate matter,
Right.
is capable of making contact. And now that I'm looking, the answer to your question earlier is no. They talk about the smoker's battery and say that substantial certainty that the smoke's going to make contact with you is not enough.
But I thought substantial, now I'm scratching my head in mock puzzlement, because I thought that substantial certainty was sufficient to establish intent for a battery.
Yeah, I mean that's pretty much what we've been reading so far. But I mean the substantial certainty is a little bit different than directly blowing smoke into somebody's face.
Yeah, the court may have wanted to sort of limit the liability, and yeah, it's substantially certain it's going to make contact with someone. Usually that's enough, but I think the court may have had a real fear of liability here. If smoking is allowed in the building, right? Do you get to sue everybody just because it's offensive to you? So the court really is zeroing in on what's offensive and what made this particularly offensive, as opposed to just smoke being everywhere.
That it was very intentional. Like he got up, lit the cigar in his face, and then blew it.
Yeah, exactly. So the court's looking for more than your usual kind of lofty, substantial certainty here, right? It really wants specific evidence of offense against a certain person. And I think it has to do with the fact that smoke, even though it has particulate matter, right, it's still diffuse, right? It's not like throwing something at someone or, just having things around that you might throw willy-nilly. This is just a cloud. And then even trying to identify which person's smoke had made contact with you. Wouldn't that be a proof problem as well?
Right, because I was thinking about, in the context of now, how we were saying smoking was much different decades ago than today. Like, you walk into a bar today, you could, in theory, sue everybody if smoking's allowed. And that's just not efficient.
That's right. And the way we handle that now is in certain places, smoking is allowed in certain bars. They have a dispensation. If I walk into a bar like that, without knowing, I'm probably going to walk it right out. Because you can tell immediately that people were smoking, right? So there, I think we're still trying to work out the rules of engagement, right, about when this was offensive. And let me just follow up by asking this question. Do you think this would be a good case for punitive damages?
Well, they say it's possible. I mean, it could even just be $1. I guess that would be something the jury would kind of come up with, but myself, I think so. I mean, it's
deliberate. It's disrespectful. It's deliberately, offensive. I mean, it's not an accident. And the whole idea of punitive damages is we don't have much by way of compensatory damages here. We want to deter this guy and other people from engaging in this kind of behavior. What about people smoking in an elevator? Would that be a similar situation? Let's say there are 4 people smoking in an elevator. We're back in the 90s, all right?
Okay.
So, whatever music and fashion that calls up for you, I don't know. But we're back in the 90s, and 4 people in the elevator are smoking, and you walk in, and they're not blowing smoke at you, but the whole elevator is full of smoke.
Yeah, I mean, my mind was kind of at now, which obviously, but back when this case was written, based on the way they talk about smoker's battery and everything, unless somebody was smoking and then purposefully blowing smoke or lighting a cigarette and letting it waft into your face on purpose.
Yeah.
In 1990, I think this is 4. Probably not a battery. Then.
Yeah. Well, right. Right. Unless you have some specific.
Now it's just against regulations.
That's right. So people would smoke in elevators. They would smoke in cars. They would smoke in oxygen tents. I mean, I'm kidding about that. Airplanes, which is crazy when you think about it. It's like there's a smoking section. In other words, the whole plane in that case, right? So, one last sort of question that some of your classmates might have found interesting is, what is a per curiam opinion? This case is written by the court per curiam. What does that mean?
It's just by the court.
It's just by the court. That's all it means. And courts don't often do this, right? Any idea? You can speculate here as to why the court might have done that in this case.
I was thinking just because it is coming from one source instead of differentiated opinions, and it's just
it's clear. The court's establishing a clear rule. They don't need to assign it to any particular judge. The court wants to emphasize that it's speaking with one voice. I think that's probably all you need to know about that. But it is unusual to see a per curiam opinion.